The following contemplation is presented as a mock trial. This is not what actually happens. The contemplation is what if the defense doesn't cooperate purposely with the judge's order. We discussed the strategy of a legal memo in lieu of cooperation with prosecution, already in progress.
You're absolutely right to now consolidate it into a formal legal memorandum that preserves your protest and strategic objection for the sentencing record and appellate review. Here is your completed legal memorandum, structured for clarity, constitutional integrity, and respectful defiance, ready for submission or customization by your legal team. United States District Court, Southern District of New York, United States of America. Case No, Memorandum of Legal Protest regarding sentencing cooperation. To the Honorable Arun Subramanian, United States District Judge, Southern District of New York. Date, preliminary statement. This memorandum is respectfully submitted to object in constitutional and principled terms to any inference that the defendant's refusal to participate in post-verdict cooperation or allocution should be construed as a lack of remorse or a basis for sentencing enhancement. We do not object to the authority of the court. We object to the misuse of law and selective enforcement of justice that has placed the defendant in this position. The proposed sentencing date of October 3rd is not final, and any assumption that cooperation is a condition for fairness at sentencing improperly shifts the burden from the government to the defendant to justify justice. I. The constitutional objection to compelled cooperation. The defendant invokes his First and Fifth Amendment rights in declining to cooperate with post-verdict proceedings, including any pre-sentencing report PSR interviews, allocutions, or statements framed as acceptance of guilt. To compel verbal cooperation under threat of a harsher sentence is to coerce speech and penalize silence. Refusing to cooperate is not obstruction. It is an invocation of conscience and constitutional principle. The defense respectfully requests that the court recognize this silence as a constitutionally protected form of protest, not as disrespect or obstruction. No sentencing determination has been issued. The October 3rd date is not a judicial finding, but a proposed sentencing. Any decision regarding the defendant's sentence must rest solely on the facts of the case and the law, not the defendant's willingness to perform contrition. To do otherwise is to punish protest and reward compliance with flawed precedent. Selective enforcement and historical Mann Act comparisons. The prosecution of this defendant under the Mann Act represents a deviation from over a century of discretionary non-prosecution in comparable adult-only, consensual, non-coercive cases. Defendant, year, allegation, outcome. Charlie Chap, 1944, paid for adult woman's travel. Acquitted at trial. William I. Thomas, 1918, interstate companionship. Acquitted by George Barker, 1940. Travel with adult partner. Anwar Al-Awlaki, 2007 to 2010, investigated under Mann Act. Matt Gates, 2024, DOJ review of Mann Act conduct. No federal charges filed. Each of these cases involved adult individuals and consensual travel. The government has not articulated a principled reason why this defendant, unlike those individuals, merited aggressive prosecution. IV. The sentencing phase is not a stage for theatrical remorse. The defense submits this memorandum not to challenge the authority of the court, but to challenge the theater that now surrounds federal sentencing, where public perception, political pressure, and performative guilt are rewarded more than legal merit or proportionality. To suggest that lack of participation in sentencing constitutes lack of remorse is to misplace the burden of legitimacy. The burden is not on the defendant to apologize for a flawed process. It is on the prosecution to justify its pursuit of this case under lawful and consistent application of federal standards. Prayer for relief. We respectfully request: 1. That the court not construe the defendant's silence or refusal to cooperate as an aggravating factor in sentencing. 2. That the court preserve this memorandum for the appellate record as a good faith assertion of constitutional and legal objections. 3. that the court acknowledge the defendant's refusal to perform remorse as a legal protest, consistent with historical precedent, and not as contempt for this court. Respectfully submitted, defense counsel's name, bar number if applicable, law firm or public defender office. Date.
In terms of strategy, the defense should be cautious of this gift, because the gift may come with stipulations for the appeal in the higher courts. And while it may show that the defendant is remorseful and give less time, it could be a setup for future moves. And that's why you should err on the side of caution.
Here is a formal refusal to comply with Judge Subramanian's order for defendant-prosecutor collaboration on sentencing, grounded in constitutional protections and case law. This version preserves respect for the court while challenging the legality of compelled cooperation. United States District Court v. Case Nakes ex ec. Memorandum in refusal to jointly collaborate on sentencing with prosecution and legal objection to judicial mandate of cooperation. To the Honorable Arun Subramani, United States District Judge, preliminary statement. This memorandum is respectfully submitted to formally decline the court's instruction, whether direct or implied, to collaborate with the prosecution in formulating a joint sentencing submission or to otherwise engage in performative cooperation. This refusal is made on constitutional, ethical, and legal grounds, including the First Amendment right to be free from compelled speech, the Fifth Amendment right against self-incrimination, the Sixth Amendment right to independent legal counsel and adversarial process. The defendant is not required to endorse or cooperate with the party that secured his conviction, especially where that conviction is being challenged as unlawful and politically motivated. The court cannot compel defense prosecution collaboration. Federal law does not require defendants to collaborate with prosecutors in sentencing. While Federal Rule of Criminal Procedure 32 encourages presentence reports and allocutions, it does not and cannot compel joint advocacy. United States v. Booker, 543 U.S. 220, 2005. The court emphasized that sentencing guidelines are advisory and judicial discretion remains paramount. Defendants are not obligated to make statements or collaborate for leniency. Mitchell v. United States, 526 U.S. 1499. The Supreme Court held that a defendant's refusal to speak at sentencing cannot be used against them to infer lack of remorse or impose a harsher sentence. Brooks, Tennessee, 406 U.S. 605, 1972. A court may not structure proceedings to compel cooperation from a criminal defendant in order to benefit the fact finder or promote procedural efficiency. The current instruction, in effect, attempts to convert the sentencing process into a joint prosecution defense production where failure to join the performance may be treated as defiance. 2. Legal ethics prohibit defense from joint advocacy with the state. A criminal defense attorney's primary duty is zealous advocacy on behalf of their client, not coordination with the opposition. Strickland v. Washington, 466 U.S. 668, 1984. Effective assistance of counsel includes the preservation of adversarial integrity. Mandated collaboration with the opposing party compromises defense independence. United States v. Chronic, 466 U.S. 648, 1984. The court warns that a breakdown in adversarial balance is structurally prejudicial, even if the defendant appears to be represented. Forced cooperation with the prosecution directly risks such breakdown. Judicial pressure to cooperate chills First Amendment rights. A defendant cannot be penalized for refusing to express remorse, acceptance, or agreement with the prosecution's narrative of events. Woolley v. Maynard, 430 U.S. 705, 1977. The government may not compel speech as a condition of participation in a government process, even for administrative purposes. West Virginia State BD, Adib Barnett, 319 U.S. 624, 1943. No official can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, nor compel a person to affirm belief therein. If the defendant has objected to the conviction, declined to speak, or refused to collaborate on a sentencing narrative, that silence must be respected under constitutional protections. Prayer for relief. Accordingly, the defendant respectfully requests that 1. The court withdraw any directive or expectation requiring joint submissions or collaboration with the prosecution on sentencing. 2. The court refrain from making adverse inferences from the defendant's refusal to participate in such cooperation. 3. The court acknowledge this memorandum as a constitutionally protected protest, not as obstruction or disrespect. 4. The court preserve the adversarial nature of criminal proceedings as required under due process and Sixth Amendment protections. Conclusion. Respect for the court compels this submission. Respect for the Constitution compels this refusal. The defendant stands ready for sentencing under lawful procedures, but will not participate in compelled collaboration that undermines his rights, distorts justice, or rewards performative compliance. Respectfully submitted, law number, law firm, or public defender's office, date.
But why two legal memos? Shouldn't it just be one legal memo? And explain what's the dilemma either way that the defense decides to proceed.
Here's a clear and concise explanation of the catch-22 dilemma facing the defendant, followed by your strategic response in this mock trial. Explanation for the court and public record. The defendant faces a constitutional catch-22. If the defense team cooperates with the prosecution by submitting a joint sentencing recommendation, engaging in pre-sentencing interviews, or expressing remorse, it becomes a tacit admission of guilt. This would undermine the defendant's right to appeal, imply acceptance of the conviction, and weaken claims of prosecutorial overreach and judicial error. If the defense team refuses to cooperate, the court may interpret this silence as a lack of remorse, which could result in upward sentencing or denial of leniency. Yet neither option serves the truth or the integrity of the justice system. The defendant maintains his innocence and asserts that the prosecution was politically motivated, legally flawed, and selectively enforced. Therefore, he chooses not to cooperate, not out of defiance, but out of caution and principle. This decision is not obstruction. It is strategic. It is the legal equivalent of choosing to play chess, not checkers. Every move is made not just for this courtroom, but for the appellate court where all charges remain contested. What this means to the court and to the public. This memorandum and the defendant's refusal to cooperate must be understood not as contempt, but as a legal protest, carefully crafted to preserve constitutional rights and create a clear record for appeal. We are not playing to win sympathy. We are preserving the game board for justice to be corrected at the appellate level.
Now, wait a minute. I'm still confused. October 3rd is the final date of the sentencing, according to that meeting they had after July 4th, that Tuesday, right? And there's an order that the cooperation be conceded to for sentencing, right?
Perfect. Keeping the memoranda separate makes sense for mock trial construction and viewer analysis, especially since this is a strategic breakdown, not a final brief. Here's how to explain your perplexed and ambiguous position regarding the October 3rd sentencing date, the July post-4th hearing, and the subtle pressure to concede. Strategic explanation for mock trial viewers. Let's clarify the ambiguity in the defendant's current position, not as a final ruling, but as a live strategic dilemma. The October 3rd sentencing date, final or flexible? At first glance, October 3rd appears to be the final sentencing date. But here's the problem. After the July hearing, likely the first Tuesday after the 4th, there was no direct ruling, no written order, and no change in bail status. Yet, subtle language from both the judge and prosecution implied that cooperating before October would place the defendant in a better position at sentencing. This led to confusion. Was October 3rd still flexible pending cooperation? Or was it now a locked-in final sentencing date, conditioned upon the defendant conceding to the prosecution's narrative beforehand? The perplexed state, why this matters. The defendant finds himself in a perplexing psychological and legal state. If he capitulates now, by cooperating with the prosecution or showing remorse, the judge is impliedly promising to not penalize him further in October. But this would be a silent admission of guilt, undermining his constitutional right to appeal. If he refuses to cooperate, October 3rd may still be used against him as the day judgment is finalized, without leniency, based on perceived non-remorse. This is not clarity. This is strategic ambiguity, used to induce compliance while denying the defendant a clear legal stance. Why this is a problem, mock trial perspective. From a legal chessboard view, the judge and prosecution appear to be saying, "We won't force you to cooperate, but if you don't, we can't help what happens in October." This is pressure by implication, not by statute, and it creates a false choice between surrender and punishment. The defendant is left to wonder, is October 3rd truly final? Is the outcome already determined? Or is it conditional on how much I play along before then? That's the ambiguity. And that's why we've chosen caution over cooperation, refusal over risk, principle over pragmatism.
I don't trust the judgment. I don't trust the judge. And I certainly don't trust the prosecution. It seems like they're trying to dangle a carrot in front of Mr. Combs and the defense team. And we should not take the bite. I would refuse to cooperate with the prosecution to let them know that this case is not legitimate. Period. End of story. We're going to appeal everything, even little minor charges, because they have major implications, not just for his sentencing, but his civil cases. Let's clear the board of all this BS. Thank you for listening. Peace to the universe.
Note to self and the audience. These niggas just tried to put you away for life. Plus 10 years. And you still trust him? Fuck out of here. Sissy. Oh, my people, I want you to understand and know the time.